Good morning, dear participants. My name is Volkan Aslan. I'm Assistant Professor of Constitutional Law at Istanbul Law School. First of all, I would like to welcome you to this beautiful session today. And secondly, I want to thank Professor Sözer for giving this opportunity to me to moderate this beautiful meeting. The first lecture of today will be started with Professor Vincenzo Pacillo. He is from University of Modena and Reggio, Emilia, and he will give his lecture on restrictive pandemic measures and its relation with human rights. So I don't want to take lots of your time. So the stage is yours, Professor. So please.
Thank you, dear President. Good morning to all the participants in this summer school. First of all, I would like to thank Professor Sözer, my master, and my colleague Adam Sözer for inviting me today. It's a great honor to be with you. And honestly, it's a great pleasure to come back, even if not in person, but only by computer, to this summer school. I was a participant in the year 2017. The world was different. Everything was different because I had the opportunity, obviously, to stay in Istanbul and to spend one of the best period of my life studying in Istanbul for 3 weeks. And now we are together only virtually using the personal computer. But I really hope that in the future, we will have again the opportunity to meet together, because it's very important that university can share ideas and can share knowledges, not only using the computer, but obviously also seeing the person, meeting the persons, and sharing our ideas personally. In these short words, I tried to emphasize that this pandemic obviously had consequences on everyday life of each of us. And it also has a huge impact on our academic life, on our personal life. And obviously it deals with a complex of human rights, and it's up to the governments, to the legislators, to try to combine the health necessities of people with the necessity to respect, at least in its core content, human rights as provided in the international documents, and especially in the European Convention of Human Rights, signed in 1950. It's not easy because also in this situation we had a complex of laws and a complex of different documents with the deep relation, the one with the other, and where the international instruments and the national instruments are combining just to try to have a solution for this situation. It's not easy to understand exactly when the government, the national governments, the national parliaments' action can finish, can stop, and leave the floor to the international instruments. From this point of view, I will try to give my speech emphasizing more or less 3 different perspectives. First perspective is what happened at national level in Italy, because it's the country in which I teach, in which I live, and it's for me an interesting point of view of what happened. So we will start from what happened in Italy to fight the pandemic and to respect at least the core content of human rights. Then I will try to analyze how is the approach of the Italian government and of the Italian parliament taking into account the European Convention of Human Rights. And in the third part of my speech, I will try to focus on one of the main fundamental rights, basic rights, touched by the governmental and legislative action in Italy, freedom of religion, in order to understand exactly what kind of problems are arising from this intervention and what kind of perspective we have to try to solve these problems. So let's start on Italy. I will give you some dates, but dates in the sense that I will recall you some moments, some days in which the governmental and the parliament action in Italy has been developed. Don't worry if you miss something. I will prepare for you a short presentation on the main points of my speech. But now it's important to focus also on the days, the exact days, because they are very important in order to understand what happened in Italy. The first day is the 23rd of February of the year 2020. In this moment, the government adopted a decree law, the decree law number 6, empowering the president of the Council of Ministers, Mr. Giuseppe Conte, to issue further and more detailed decrees aimed at the containment of the COVID-19 pandemic. The 23rd of February is a crucial day in the Italian history of pandemic because it's the first day in which the Italian situation was not under control, became really out of control, and the government decided to implement a particular situation, a particular action in order to fight the pandemic. What is the problem? The problem is that in Italian constitution, there is not a specific rule on the state of emergency. The Italian constitution has a specific norm only to rule the emergency in the state of war. It is the Article 78 of the Italian constitution. I will read it for you. Parliament has the authority to declare a state of war and vest the necessary powers into the government. But it's the only specific case which we have a rule of the state of emergency in Italy. So the constitutional lawyers divided it into two categories in this moment. The first category decided that the pandemic was just like a war. So the Article 78 had to be used also in this specific situation because the pandemic is just like a war, an analogic use of the Article 78. This interpretation was judged as not correct, was judged as wrong by the actual president of the Constitutional Court, Italian Constitutional Court, Professor Marta Cartabia, who told explicitly that it's not possible to extend what happened and what has been decided into Article 78, what has been provided into Article 78, to a situation different from the situation of the declaration of war. So Article 78 can be used only for situations of war. From this point of view now, it's necessary to use another norm. The pandemic and the situation of emergency in case of pandemic must be ruled according to the Article 77 of the Italian Constitution, not 78, but 77. But Article 77 is more general and is not explicitly focused on pandemic issues. Let's take a look at Article 77. The government may not, without a delegation from Parliament, issue a decree having force of law. When government, in case of necessity and urgency, adopts under its own responsibility a temporary measure, it shall submit such measure to Parliament for enactment. During dissolution, Parliament shall be convened within 5 days after any such measure has been submitted. Such a measure shall lose effect from the beginning unless it is transposed into law by Parliament within 60 days of its publication. Parliament may regulate the legal relations arising from a rejected decree. What kind of things tells us Article 77? First of all, the government may enact on its responsibility temporary measures. Temporary means that you have to expressly tell when the measure starts and when the measure ends. And this happens only in cases of necessity and urgency. And the Parliament must say something on these measures. Parliament must be involved into the process of creation of these peculiar measures. Well, what happened between February and March is not so respectful of Article 77. And not that's something that it's not up to me to tell it, but this is the opinion of two former presidents of the Italian Constitutional Court, Professor Cassese and Professor Baldassarre, who explicitly told that what happened between the 23rd of February and the 11th of March 2020 is very difficult to be completely justified in the perspective of the Article 77. What happened in these days? As I told you, the 23rd of February was undersigned the decree number 6. The decree number 6 gave a lot of powers to the President of the Council of Ministers without explicitly telling what kind of powers he enjoyed to fight the pandemic and what kind of starting moment and end moment could be found from this perspective. The 11th of March 2020, there was a decree that's very strictly joined to others two decrees of the President of the Council of Ministers, undersigned the 8th and the 9th of March, restricting human rights in all the Italian Republic. These decrees were not coming from the government, but only by the President of Council of Ministers in persons, and they had a deep impact on personal liberty, according to Article 13 of the Italian Constitution, freedom of movement, according to the Article 16 of the Italian Constitution, freedom of assembly, Article 17 of the Italian Constitution, freedom to profess one's religion or belief, Article 19 of the Italian Constitution, economic enterprise, Article 41 of the Italian Constitution, and they strongly impacted as well to the right of, on the right of education, Article 33 of the Italian Constitution, because of the decision to close all the schools and to have only remote didactic. What was the main problem according to these decrees? The decree of the government, number 6 of the month of February, and the decrees of the President of Council of Ministers dating 8, 9, and 11 of March. The main problem is that, first of all, as I told you before, that was not an ending term to the capacity of the President of the Council of Ministers to decide. The President of the Council of Ministers enjoyed for a while of a power that was without a kind of temporal limitation. Second, there was no clear expression of the powers enjoyed by the President of the Council of Ministers. The President of the Council of Ministers seemed to enjoy a power without limitations in order to fight against pandemic. Third problem, what kind of role had the parliament in this process? This was not clear in any of these decrees. Well, our president of the Council of Ministers is a jurist, he's a professor of private law, and obviously he has a staff with him that is very competent. So the problem was that it was necessary to act without any kind of full respect of Article 77. And the idea probably was that in that moment, the situation was so out of control that it was necessary to act very, very fastly. But from the point of view of the jurist and from the point of view of the public law scholar, this created a very, very complex customary law, customary public law, that could be very problematic in the future to understand. In the sense that now we know that when we are in a situation of so strict emergency, the President of the Council of Ministers can act without a full respect of Article 77. From the point of view, from the juridical point of view, however, the situation was somehow refilled into the constitutional framework with the legislative decree number 19 of the 25th of March 2020. In this decree, all the things that were decided into the decrees of the President of the Council of Ministers were somehow proposed again, told again, in an act that was completely under the control of the Parliament. From the point of view, from this point of view, so from the 25th of March 2020, we have a situation that's completely good, completely without any kind of problem in the framework of the constitutional picture, of the constitutional situation. The problem is what happened between the 8th and the 25th of March, these 17 days in which we had a regulation of the human rights in Italy that was very, very, very complex and strict without a proper situation according to the Article 77 of the constitutional charter of our constitution. So from this point of view, for example, a judge in the tribunal of Frosinone, a small town in the center of Italy near Rome, decided that the sanctions that were given against people who acted against the rules of the government in order to fight the pandemic could not be applied to the person because these sanctions were somehow unlawful because unlawful was the act that give the opportunity to the judge to give the sanctions. So it's a very new decision. We are talking about a decision of a very low court at the end of July. So I cannot give you further elements on this. But the idea is that from the juridical point of view, there are some problematic issues against this 17 days situation. This is the Italian debate, but how to take the Italian debate in the framework of the European Convention on Human Rights? From this point of view, there is a very interesting document that I would like to share with you, dating the month of April, in which the European Court of Human Rights tries to give some guidelines in order to have a full respect of the conventional framework, even in the case of emergency. This is a document that you can easily find, but I will share with you, obviously. And now I will try to read some passes, some steps of this document with you, and then we will try to comment these parts together. I'm sorry, I will try, this is the document, but okay, the document is Respecting Democracy, Rule of Law and Human Rights in the Framework of the COVID-19 Sanitary Crisis, a toolkit from member states, and it's dated 7 April 2020, and it came directly from the Council of Europe. From this point of view, our starting point must be Article 15 of the European Convention on Human Rights. Article 15, I recall it for you now, it's titled Derogation in Time of Emergency. In time of war or other public emergency threatening the life of the nation, any high contracting party may take measures derogating from its obligations under convention to extent strictly required by the exigencies of the situation, provided that such measures are not inconsistent with its other obligations under international law. No derogation from Article 2, except in respect of deaths resulting from lawful acts of war, or from Articles 3, 4, paragraph 1, and 7 shall be made under these provisions. So Articles 2, 3, 4, paragraph 1, and 7 are out of the derogation system, completely out of the derogation system. Any high contracting party availing itself of this right of derogation shall keep the Secretary General of the Council of Europe fully informed of the measures which it has taken and the reasons thereof. It shall also inform the Secretary General of the Council of Europe when such measures have ceased to operate and the provisions of the Convention are again being fully executed. To be honest, Article 15 is a general framework on derogation, but we perfectly know that in the European Convention on Human Rights, we have specific situations of derogation in the single articles, in the sense that there are some articles who have inside the possibility to a derogation of that the member state can derogate to them, even if it happens only in specific circumstances. If we take a look at Article 9, religious freedom, better to say, freedom of thought, conscience, and religion, if we take a look at paragraph 2, we have a specific, the specific circumstances in which freedom of thought, conscience, and religion can be derogated by the state parties, and the specific situation in which this derogation can happen. But while in this case we have a specific situation according to which it's possible to derogate to Article 9, the Article 15 is something that is generally gives general rules to the capacity of the member state to derogate to the fundamental rights expressed in the European Convention. Well, from this point of view, the Council of Europe is very clear in putting Article 15 in coordination with the principle of legality. In our document, we find even in an emergency situation, the rule of law must prevail. It is a fundamental principle of the rule of law that state action must be in accordance with the law. The law in this context includes not only acts of parliament, but also, for example, emergency decrees of the executive, provided that they have a constitutional basis. Let's take a look, starting from this to the Italian situation. Okay, when we talk about rule of law and principle of legality, in the framework of the Council of Europe, we cannot consider only the acts deriving from parliament. It's clear, it's very clear in the jurisprudence, in the case law of the Court of Strasbourg, that when we talk about rule of law and principle of legality, we talk always about acts deriving not only by the parliament, but also from the governments. But obviously, the acts deriving from the governmental powers, the acts of law deriving from the government, must be given according to the constitutional law of the member state. And as we told, in Italy, we had a big problem on this, in the sense that at least for 17 days, these acts deriving from the government, better to say, from the president of the council, were probably not given on constitutional basis. Let's go on. Many constitutions provide for a special legal regime or regimes, increasing the powers of the executive authorities in the case of war or a major natural disaster or another calamity. This is another big problem in Italy. I really remember that moment with specific honor and specific satisfaction. But in 2017, I was invited by the Turkish Constitutional Court to talk about the state of emergency in Italy. And what I tried to emphasize in that moment was that in Italy, we had no specific rule on the state of emergency. Better to say, we have some specific rule, but they are not linked to the constitution. The main rules on the state of emergency in Italy are given by a law, a normal law, not a constitutional law, a normal law of the parliament on the civil protection. And on the civil protection, on this law on the civil protection, we found the basis for the state of emergency in Italy. But you can perfectly understand that to link a very, very problematic situation, just like the state of emergency, to a normal law enacted by the parliament without any kind of constitutional basis could create some problems, and it created some problems in this case. From this point of view, a lot of constitutional lawyers, a lot of constitutional scholars, constitutional law scholars, proposed to renew the constitution and to put something explicitly on the state of emergency in the constitution. But once again, the president of the Constitutional Court, Professor Marta Cartabia, responded to these instances, telling that it was not necessary. It is not necessary, according to Marta Cartabia, because the Italian Constitution has in itself all the basis in order to create a proper balancing between the necessity to fight the pandemic and to assure the right to public health and to ensure the enjoyment of the other constitutional rights. In that words, Marta Cartabia renewed the emphasis on the balancing. The balancing is, the balancing operation, the balancing action is, according to the Italian constitutional law school, necessary whenever there is something that can impact on fundamental rights. When we have two fundamental rights clashing one with the other, it's always necessary not to have a sacrifice, an absolute sacrifice of one of these rights in order to assure the full enjoyment of the other. But it's always necessary to balance the two rights in order to give a little, at least a little chance to be enjoyed, also to the constitutional rights that's considered less important than the other. This is a tradition, this is a point of view, this is something that is very common in the decision of the Italian Constitutional Court, and also in the pandemic, the necessity is the necessity to balance. It is very important, and we will tell it again, when we will talk about the religious freedom. Let's remember this necessity to have a proper balance, because it will be a very core content of our speech on religious freedom that we will try to do in the second part of our lecture. The second point emphasized by the Council of Europe is that it's necessary to have a limited duration of the regime of the state of emergency and of the emergency measures. The problem is the temporal extension of the necessity measures. And this is a very crucial problem. First of all, because it's not so easy to understand how long this pandemic can persist. In Italy, we have a strange situation. After the 27th of April and first days of May, more gradually, all the fundamental rights were assured again in their full extension, without only specific limitations. But this created, in the last days, a very, very uncontrolled increasing of the pandemic. And this obviously gave to everybody a very, very sensation of danger. So the government was had to act again in order to close the ballrooms, the discotheques, the places in which young people, but generally people, gathered to dance. Because it was not possible to assure the necessary distance, interpersonal distance of 1 meter between one person and the other person, and it was not possible to assure that the pandemic could put under control in these cases. Somebody told, is it possible to create a limitation of a fundamental right, to give a new enjoyment of this fundamental right after a certain moment, and then to close again, to compress again, to limit again this fundamental right? This is not clear. This is not clear also from the problem of this limited duration of the regime. From this point of view, it's clear that probably it's very difficult to have a proper limited duration of the regime of the state of emergency, because no one can really understand when and how the emergency can last through the time. So from this point of view, this point emphasized by the Council of Europe is very problematic to assure. It is very problematic also to focus on the third point emphasized by the Council of Europe, even especially if we think about the situation in Italy. The third point is limited scope of the emergency legislation, the principle of necessity. The Council of Europe expresses its ideas this way. The principle of necessity requires that emergency measures must be capable of achieving their purpose with minimal alteration of normal rules and procedures of democratic decision-making. I think that we have to distinguish the two situations. One thing is to say the state of emergency must create a minimal alteration of the procedures of democratic decision-making. We talked about this when we talked about the role of parliament in the Italian situation. And we told that, in effect, it's necessary to assure that the government acts in accord to the parliament. No? But let's focus on the first part of these words. The state of emergency must create a minimal alteration of normal rules of democratic decision-making. Therefore, the power of the government to issue emergency decrees should not result in a carte blanche given by the legislature to executive. Given the rapid and unpredictable development of the crisis, relatively broad legislative delegation may be needed, but should be formulated as narrowly as possible in the circumstances in order to reduce any potential for abuse. This is the problem, the potential for abuse. Sometimes it's not so easy to say explicitly how it's possible to create a derogation of the fundamental rights in a way that is as narrow as possible what does it mean in a certain situation as narrow as possible? In the month of March, when the Italian government decided to close, to abolish de facto the freedom of movement, also in the same town, for the generality of the people, how is it possible to say what is the situation in which this compression can be as narrow as possible? In Italy, we had the big problem, for example, it seems funny now, but it is not funny, of the runners, of people involved in running activities, because it was impossible for them to exercise them in their activity of running, because there was the obligation to stay home. The obligation, not an invitation, the obligation. In Italy, there was a different choice between what happened, for example, in Britain or in Switzerland, in which there was a strict advice to stay home, but not an obligation to stay home. In Italy, there was the obligation to stay home. So the people involved in running activities told, it's impossible for us to make our favorite sport, running, but this is a measure that's not reasonable, because when I go out for running, I'm alone, and I'm not with other people, so I have no chance to create dangers for other people. The answer of the government is it's impossible to rule exactly what will happen if 60 million of Italians became runners in one single day. No, because the idea was that one of the possibility of the chance to go out from home, and you perfectly know what does it mean to stay home for weeks. And so the danger was that everybody in Italy became a runner. So we had 60 million people running through the streets, and it was impossible. So from this point of view, it's very difficult to understand when a measure can be considered as necessary and when a measure can be considered that's not so necessary in order to achieve the goals. So one thing is the procedure. One other thing is the core content of the measures. The fourth point emphasized by the Council of Europe is the distribution of powers and checks on the executive action during the state of emergency regime. And there is a very important point that is emphasized in this part. Parliament, however, must keep the power to control executive action, in particular by verifying at reasonable intervals whether the emergency powers of the executive are still justified, or by intervening on an ad hoc basis to modify or annul the decisions of the executive. In Italy, there was a moment in which the parliament was completely out of this kind of control. And this is obviously a problem. This must be absolutely ruled, because otherwise there is the risk that the executive can adopt different legislations, different acts, without a proper intervention of the parliament. So these are the four main points that we have tried to emphasize. I would like just to close this first part of our lecture on a particular right, not freedom of religion, we will talk about it in the next part, but now I would like to close on the right of education. The problem is the right to education that is explicitly granted by the Italian Constitution in Article 33 of the Constitution, but obviously also from other parts, other international instruments. It's one of the fundamental instruments provided by international charters, must be read always in accord with the prohibition of discrimination according to the Article 14 of the Convention and Article 1, Protocol number 12, Article E of the European Social Charter. Right to education means right to education without any kind of discrimination. Well, in Italy, we adopted the solution to grant the right to education using the online resources given using a sort of school, a distance school, in which teachers were connected from their home, and pupils were connected by computer staying at home. Obviously, there is a great difference between the educational system in universities and the educational system in primary and secondary schools. When we talk about university, more or less the situation and the system worked. We managed our lectures staying home, and the students had the possibility to follow our lectures, to interact with us using Zoom or other instruments, other tools. We made our exams online, and I must say that somehow the situation worked, but we're talking about a situation in which students are at least 18, 19 years old. They are mature people. They are people completely devoted in their actions, and we must say this, it's not compulsory to go to the university. So if you are at the university, you perfectly know that is a part of your personal life, and you can manage it without any kind of problem, but according to your own responsibility. The situation is very different for the compulsory schools and for kids, children. From this point of view, we had a very, very huge situation of children that had no possibility to connect, who had no possibility to follow correctly the lectures of their teachers, who had not the concrete possibility to express their problematics and to have somebody who was able to solve their problems of knowledge. From this point of view, I think that is very, very important to create a link between the right of education, the right to education, and the right to internet access. We have no constitutional rule in Italy on the right to internet access. There was an Italian jurist, a famous Italian jurist, Stefano Rodotà, who worked a lot on this and made a lot of proposals about this, but we had now no possibility now to have such a norm. There is no norm, such a norm on the constitutional charter in Italy. So the problem was that de facto, some students, and not a huge number of students, were completely casted out from the system of education. And so the pandemic and the instruments to rule the pandemic create a very, very sensitive and problematic gap between these people, these students, these children, and the other children. From this point of view, I think that is one of the main actions that must be taken in order to assure to everybody not only the right to education, that's the fundamental right, but the right to grow up without hurdles that can impact on your personal life and on your personal expectation. And it's one of the main points that we have to implement in order to fight against discrimination. So I think that probably one of the aspects that must be being taken into account now is to involve the right to education and to manage the right to education in the perspective given, the new perspective given by the pandemic. More or less, this is the framework in which we move. My proposal now, I don't know if the president is agree, is to have a break, 10 minutes when you prefer, and then to come back again in order to try to have a reasoning on all these things that we try to tell in general framework, especially on the right to freedom of religion.
Thank you, dear professor. So we will have 10 minutes of break. So see you each in 10:25. Thanks. So, okay, dear participants, now we are in the second session of the lecture of Professor Vincenzo Pacillo from the University of Modena and Reggio Emilia. He will go on with the restrictive pandemic measures and its relation with human rights. So please, Professor, go on.
Thank you. Thank you, dear Volkan. One of the problems of this remote conference is that it is not possible to enjoy the wonderful Turkish coffee. We have to use the Italian coffee. It's not the same thing, obviously, but we will try to make it somehow. Okay, let's start from the moment in which we left 10 minutes ago. And we try to focus now to the right to religious freedom and what happened with the pandemic. Because in Italy, the situation is quite interesting and important from a lot of perspective that I will try to emphasize. Let's remember what we told about what happened in the days 8-11 of March 2020. The decree number 6 of February, 23rd of February, gave to the President of the Council of Ministers the powers to make decrees in order to restrict human rights and to fight the pandemic. And we told that it is this decree is quite complex in the perspective of the constitutional law, Italian law. However, the President of the Council of Ministers gave his decrees in the days 8-11 of March. 8 of March, the measures were only provided for a part of Italy, Lombardy, a part of the region Emilia and Romagna, and so on. While the 11th of March, all these measures were extended to all the Italian territory. There were a lot of measures provided, but the most important were that all gatherings of people were forbidden and the movement of people was restricted, including within the same town, to exceptional circumstances of necessity, for example, buying groceries, but not only groceries, but only, for example, buying tobacco to smoke. It was possible to go to the tobacconist and buy tobacco to smoke. Health reasons and demonstrated work-related exigencies. People circulating anywhere on the national territory, including on foot, what we told about the runners, can be stopped by law enforcement officials and asked to make a written declaration justifying how their being outside falls within one of these exceptions. All the trade was suspended, save for essential goods and so on. But, however, the impact was very deep. And one of the measures provided in this ban for gathering was the impossibility to celebrate public acts of worship and the impossibility to go to a place of worship to pray. This possibility was not considered to be included into these exceptional circumstances of necessity that were one of the causes according to which it was possible to go out from his or her own house. So it was banned to perform public acts of worship, and it was unlawful to go to the church to pray. This obviously impacted with the freedom of religion that obviously is granted by the Italian Constitution. The norm is Article 19 of the Italian Constitution, in which we have the possibility to derogate to the general freedom of religion for circumstances that are not included in this situation. Let's take a look to the Article 19. Everyone shall be entitled to profess freely their religious beliefs in any form, individually or with others, and to promote such beliefs and celebrate rites in public or in private, provided they are not offensive to public morality. That's the only limitation expressed in the Constitutional Charter, but we could say, according to the balancing theory that we tried to focus in the past lecture, the necessity to preserve the right to life, the right to health, must be balanced with the freedom of religion. So, for someone, it was not unlawful to create these derogations to the freedom of religion in order to fight against pandemic. But there is another problem in Italy. And the problem is explicitly linked to the Catholic Church. And it's not from a sociological point of view or from the fact that Italy is generally considered a Catholic country. It is a lawful problem because in Italy we have a special regime for the Catholic Church. And this regime is explicitly granted in Article 7 of the Constitution. Article 7 of the Constitution tells, the state and the Catholic Church shall be independent and sovereign, each within its own sphere. Their relations shall be regulated by the Lateran Pacts. Amendments to such pacts, which are accepted by both parties, shall not require the procedure of constitutional amendments. Now, I have a class of ecclesiastical law in which I try to explain this article in more or less 12 or 14 hours. So it's very difficult to explain it into 2 minutes, but I will try to focus the main problems of these articles. This article, the Article 7 of the Constitution, creates a proper concordat regime in Italy. In Italy, the relationship between the Republic and the Catholic Church are regulated by a concordat. When the Constitution talks about Lateran pacts, to be honest, it talks about 3 different documents. The Lateran Treaty, that was undersigned in 1929, and it created, for example, this Vatican City, the state of Vatican City. And this is the main aim of the Lateran Treaty. The Lateran Concordat, that was undersigned in 1929, but it was fully amended in 1984. So we have now a Concordat that, even if can be included into these Lateran pacts, however, it's quite new because it has been undersigned in 1984, and so after the constitutional charter that was undersigned in 1948, so it's a different situation between the Lateran Pacts of 1929 that was undersigned under the fascist regime, and then a financial a financial agreement between the Holy See and the Italian government, but this is not relevant for us now. The relevant document is the Lateran Concordat and its modification of 1984. It's important because the Article 2 of the Concordat gives to the Catholic Church the right to use freely and without any kind of limitation, to exercise freely and without any kind of limitation the spiritual power of the Church, the Catholic Church, and to express this power also in acts of worship without any kind of intervention by the state. The fact that at a certain moment, the President of the Council of Ministers, with his own act, suspended the public ceremonies of the Catholic Church in Italy. Is it something that is according the Concordat, or is it something that against the Concordat with the Holy See? The problem is more complex than it seems, because we have, first of all, to understand what is a Concordat from the point of view of a jurist. From a legal point of view, what is a Concordat? Probably I have an audience that is worldwide, so in a lot of countries from which you are connected to this wonderful summer school, there is no Concordat. But the idea of Concordat, for example, is quite popular in Europe and also in the south part of America, not necessarily in every part of South America, but some countries are more linked to the idea of Concordat than others. And also in Africa, we have some Concordats. And the problem is that for a lot of international lawyers, the concordat is something that can be, without any kind of problem, assimilated, can be considered equal to an international treaty. Concordat is not an international treaty, but is something that being considered equal to an international treaty. Now you perfectly understand that the problem is wider than it seems, because when the President of a Council of Ministers declares something that is in contrast with something that is written in an international treaty, is breaking an international treaty. And so we have to understand if he can do it or not. To be honest, not only in Italy, not everyone in Italy agrees with the fact that the Concordat is an international treaty. For someone, Concordat is a public law document, and so the regime is completely different. But to be honest, again, at least 9 international lawyers on 10 international lawyers consider the Concordat just like an international treaty. So the problem exists. It's not something that is also only in my mind. And this can be explained with the fact that the Holy See, as you know, has been considered as owner of international personality, is an international subject. Some bodies not agree, but the most part of international lawyers, I would like to know my colleague Kaya's idea. I greet him if he's online. But however, there is a debate on international lawyers, but nowadays the most of international lawyers consider the Holy See as an international subject, so the Concordat can be assimilated to it. So my question is, can a government, in order to fight a pandemic, break an international instrument just like the Concordat, and so can break the rights and the fundamental rights connected to this international treaty? Let's consider that the Concordat has no, between the Italy and the Holy See, has not a specific rule for this situation, but it has a very general rule that is quite clear. This rule states, if there are some problems in order to apply the rules in the Concordat, must be created a commission, a mixed commission, 3 representatives of Italy and 3 representatives of the Holy See, in order to discuss how to implement the Concordat. So there is not a specific norm for the solution of the problem, but the problem must be solved talking between the Holy See and the Italian Republic. And this has not been made. The commission was not created. The commission at the moment results completely non-active, is not acting, just like a commission, is completely still. And the decision was taken only by the President of the Council of Ministers. How to solve the problem? Honestly, I will tell you that I will try to focus on this problem from the point of view of the international lawyers, in the sense that I will consider that the Concordat can be treated just like an international treaty. And from this point of view, you perfectly know that there is a Vienna Convention on the laws of treaties, according to which there must be a solution in this case. We have 2 problems. First of all, the Vienna Convention cannot be applied directly to the Concordats, even if the Concordats can be considered similar to the international treaty, because the Article 3 explicitly says that this kind of agreements are out of the convention. But from another point of view, Article 3 explicitly tells that the general rules expressed in the convention that can be considered as a part of the general international law, customary international law, can be, however, used. Let's take a look at Article 3. The fact that the present convention does not apply to international agreements concluded between states and other subjects of international law, or between such other subjects of international law, or to international agreements not in written form, and this is the case of the Concordats, international agreements concluded between states and other subjects of international law, the present convention does not apply. But this fact does not affect A, the legal force of such agreements. These agreements are, however, legal agreements. B, the application of them of any of the rules set forth in the present convention to which they would be subject under international law independently of the convention. C, the application of the convention to the relation of states as between themselves under international agreements to which other subjects of international law are also parties. This means that if there is an international general customary rules that is recalled by the convention, it can be used also in this case of the concordats, even if, generally speaking, the case of the concordats are not recomprehended in this regulation. Here we have a rule, because the general customary rules on these cases is the general principle pacta sunt servanda. It is Latin. The agreements must be observed by the parts. Pacta sunt servanda. Agreements must be respected. Okay? This implies that, generally speaking, an agreement must always be respected by all the parts. And there can be only a specific number of reasons according to which these pacts, just like the concordats, can be derogated. The Vienna Convention talks about the situation of, let's go to the Article 61, supervening impossibility of performance. A part may invoke the impossibility of performing a treaty as a ground for terminating or withdrawing from it if the impossibility results from the permanent disappearance or destruction of an object indispensable for the execution of the treaty. If the impossibility is temporary, it may be invoked only as a ground for suspending the operation of the treaty. This situation, however, seems not to be applicable in the case of the Italian Concordat with the Holy See and to the limitation of the public worship of the Catholic Church, because the norm explicitly talks about the permanent disappearance or destruction of an object indispensable for the execution of the treaty. For example, if two international subjects, two states, make a treaty on a river, for example, about the use of the waters of a river, and this river suddenly runs dry, obviously we have not more the object indispensable for the execution of the treaty. This is the case of Article 61, but not the fact that we can and we must suspend the concordat because of health reasons. This situation of force majeure or state of necessity is not explicitly ruled by the Vienna Convention. It is more taken into account by another international document that is always applicable to the Concordat, if we consider the Concordats as an international treaty, as something that's similar to international treaty. That is the document titled Responsibility of States for Internationally Wrongful Acts. This document on the responsibility of states for international wrongful acts rule the situation in which a certain state violates the norms included in a treaty, and it rules when the violation of the norms can be considered as lawful because of peculiar situation. For example, there is an Article 23, force majeure, according to which the wrongfulness of an act of state not in conformity with the international obligation of that state is precluded if the act is due to force majeure, that is, the occurrence of an irresistible force of an unforeseen event beyond the control of the state, making it materially impossible in the circumstances to perform the obligation. We must take into account also Article 25 of this document, titled Necessity. Necessity may not be invoked by a state as a ground for precluding the wrongfulness of an act not in conformity with an international obligation of the state unless the act, A, is the only way for the state to safeguard an international interest against a grave and imminent peril, and B, must concur both these circumstances, does not serially impair an essential interest of the state or states towards which the obligation exists, or of the international community as a whole. The situation of necessity seems the most linked to the situation of the suspension of the Concordat, in the sense that it's clear that the Italian state invoked the necessity in order to safeguard its essential interest against the grave and imminent peril of pandemic. The Concordat has been suspended because of the state of necessity. But this suspension does not derive from Article 61 of the Vienna Convention, but on the Article 25 of this document about the responsibility of states for internationally wrongful act, year 2001. However, this document does not exclude the necessity that the procedures provided and set forth in the treaty, or in the Concordat in this case, must be respected. And from this point of view, it's quite curious, it's quite problematic, the fact that the commission, the mixed commission between representatives of the Holy See and the representatives of the Italian Republic, this commission has not been created in order to discuss how to apply the suspension of the Concordat to this specific situation. It gives, from the international perspective, but also from the perspective of the Article 7 of the Italian Constitution, some problems. But honestly speaking, this situation of the freedom of religion with a specific focus on the Catholic Church gave also other problems. For example, when we talk about freedom of religion, the general case law is focused on this distinction, the distinction between forum internum and forum externum of religious freedom. If you take a look at the international documents, or better to say, to the international case law on the freedom of religion, you always find this distinction between forum internum and forum externum. What does it mean? Forum internum is something that's strictly related to the freedom of conscience, and is something related to the relationship between the conscience and the religion. It means the possibility to choose a certain religion, to be a part of a certain religion, or not a part of a certain religion, or to refuse a certain religion. Something that's strictly concerned between the relationship between the person and the religion issues. While the forum externum is something different, is something that is related to the external acts of worship and the external perspective of the religion, the way in which you act, the way in which you pray when it's something that is relevant for the public, and so on. Generally speaking, the public acts of worship, just like the masses, for example, in the Catholic tradition, are considered as an act of form externum, because it's something that if you have to go to the mass, you have to go out, you have to go to another place, you have to pray in another place, and so on. But in the Catholic tradition, in the Catholic theology, we find some acts, just like the sacraments, that are involved not only with the forum externum, but also with the forum internum of the freedom of religion. I try to make an example in order to understand, even if you don't have a specific knowledge of the Catholic theology. The Catholic theology is focused on some acts just like the public confessions of, sorry, not the public, the private confession of the faults that the Catholic person feels to have against God. This confession is a relationship between the person and the priest. And it's a personal relation. There is only the priest and the faithful talking about this kind of situation. During the pandemic, it was considered as impossible to perform this kind of act. Is this act an act of forum externum or an act of forum internum? Because the problem is, the acts of forum externum can be compelled according to the international case law, can be restricted by the governments, by the parliaments, when there is a specific necessity, according, for example, to what is written and stated in the Article 9, Paragraph 2 of the European Convention of Human Rights. While the acts of forum internum, according to the international case law, cannot be restricted in any way and in any circumstances. In my opinion, this act of confession, but also, for example, the fact to receive the Holy Communion, what is called as Holy Communion. Holy Communion is a piece of bread, according to which, in the Catholic tradition, is present the body of Christ in this piece of bread. Also, this act is obviously an act that is both of forum externum and of forum internum, because it's something that's strictly involved in the conscience of the faithful, but it's also something that must be performed in a certain way. My opinion is that the borders between forum internum and forum externum are not so clear. Honestly, for me in general, not only for the Catholic faith, but also for other religions, is a little bit forced, the distinction between act of forum externum and forum internum. However, from this point of view, it would be better to create a specific agreement between the Republic and the representative of the Catholic Church in this case, but I think more in general with the representative of the religions present in Italy, in order to clearly understand what kind of acts can be considered as acts of forum internum and what kind of acts can be considered as acts of forum externum, and how to control and to limit the act of forum externum while giving to the acts of forum internum a minimum chance to be performed. Because when there is a governmental or a lawful action against freedom of religion in order to fight against the pandemic, however, the acts of forum internum must be assured, at least in their core content. So, in my opinion, this is another problem that must be ruled by an agreement. But I have another issue to say, and this is not related directly to Article 7, but to another article of the Constitution, that is Article 8 of the Italian Constitution. Article 8, it's related to the general rules according to which must be created the relationship between the state, the Italian Republic, and more in general, the religious confession, but with a specific focus on the churches and on the religious groups that are different from the Catholic Church. Catholic Church is ruled by Article 7. Other religious groups are ruled by Article 8. Article 8 provides, all religious denominations shall be equally free before the law. So you cannot provide a special regime, a privileged regime for the Catholic Church and not for the other confessions, even if the Catholic Church has a concord. Denominations other than the Catholicism shall have the right to self-organization according to their own statutes, provided these do not conflict with the Italian law. Their relations with the state shall be regulated by the law based on agreements with their respective representatives. I read again this part of Article 8. The relation between denominations other than Catholicism and the state shall be regulated by law based on agreements with their respective representatives. This means that the fact that religious denomination and the state are involved in a process of agreement is not only for the Catholic Church, but it's open to all the religious denominations present in Italy. And this implies that not only the Catholic denomination, but also the Muslim groups, the Protestant groups, the Hinduist groups, and so on, all these groups present in Italy must receive, in my opinion, a special ruling on their freedom of religion in the pandemic issues after an agreement with the state. There is not the possibility for the President of the Council of Ministers to rule by himself the relationship between the state and religious denominations, also in the pandemic issues, but these rules that obviously can limit the freedom of religion, but these rules must be created after an agreement with the religious denominations. At least after the fact that the government or the President of the Council of Ministers tries to create this agreement. If the agreement is not possible, obviously the health, the right to health, the right to life must prevail. But at least, I think, Article 7 and 8 of the Italian Constitution are very clear in order to establish that there must be a specific agreement between the state and the religious denominations in order to rule the religious freedom also in these cases of pandemic. Honestly, I wrote this at the end of March, and honestly, at the beginning of May, something happened from this point of view. Because when Italy started the so-called second part of action against pandemics, when the fundamental rights were restored in a first moment in a little way, and then in a wider way, and at the end probably in a too large way, because now we have problems again. But when there was the first moment in which the fundamental rights were restored, also the right to freedom of religion was restored. And this time, the decisions in order to restore the freedom of religion were taken after agreements with the religious denominations. The Ministry of Interior created a different moment in which representatives of the Catholic Church and representatives of other religious denominations were gathered together, obviously with the masks and with all the possible measures in order to stop the pandemic, but there was a a reunion in persons, with people in Rome, according to which they were created some protocols in order to assure the free enjoyment of the freedom of religion, also in the public worship. In my opinion, this experience is interesting for two main reasons. The first one is that the possibility to create agreements was assured, and something that was clearly shouted by part of the scholars. I was between them, but it is not important, this doesn't relevant, but I had for the first time the feelings that my academic activity had an impact on what happened really, and for the first time I have seen that this necessity was taken into account, and effectively Article 7 and 8 had an impact on the act of the government in order to restore the freedom of religion. So this bilaterality, this agreement system was protagonist, was the full and the main passage of this restoring of the religious freedom. But I think it was also an interesting experience because of the creation of the protocols. Protocols are something that derives from technical rules in order to guarantee the enjoyment of certain fundamental freedoms, even in case of pandemic. Protocols says that you can enjoy your fundamental rights if you use certain measures and certain procedures in order to minimize the impact of the pandemic. For example, it's not important that you know the rite of the Holy Mass in Italy, but you know that the rite of the Mass is a rite that's celebrated in a place in which a lot of people gather together in a certain place, and these places are often a closed place, no? Not open space place, but closed place. So in order to minimize the impact of pandemic, for example, it has been decided to admit only a certain number of people in order to assure to everybody the minimum distance of 2 meters, one between the other, okay? The use of protective masks is compulsory. It's not something that there is a debate. No, it's compulsory. If you want to go into a church, you must use the protective mask. You have to use alcoholic gel in order to wash your hands at the beginning, at the end of the celebration. You must respect all the instruction given by a service of, we could translate it, a service of order, a service people telling that everything is going under the rules, and you are obliged to follow that rules in that moment. The experience of protocols, I think, could be very useful in the future when we have to combine the necessity to assure the condition of public health. We don't know exactly how this pandemic will last and how much this pandemic will last, and we don't know if it will be the only pandemic, no, that we will have to share. But the important thing is that these protocols permit the respect of this, the enjoyment of the fundamental rights, even in these cases. And obviously, you cannot use them only in the churches, but you can use them in the workplaces, for example, or, for example, in moments of teaching, just like the schools, or culture, just like, for example, the meetings and the public meetings, the seminars, and so on. What is the problem of the protocols? The protocols cannot be soft law, in the sense that if you start telling that the protocols must be respected by people because of the willingness, the capacity of the people to use a proper norm in order to save his safety and his health, or her safety and her health, I think you're making a mistake. Protocols are not something that can be respected spontaneously, but protocols have the necessity to have a specific system of safeguard and of application. Otherwise, in my opinion, they are completely unuseful. Second, protocols are useful only if they are completely clear in order to their applicability. We as jurists use our capacities in order to make a proper interpretation of the law. There are always different interpretations of the law, and there are the tribunals, and some tribunal is influenced by certain scholars, other tribunals are influenced by other scholars, and so on. Here, there is no room for interpretation. Protocols must be applied without an interpretation, or at least with the so-called authentic interpretation, the interpretation given by the people who have the power to implement and to create the protocols. Otherwise, we cannot discuss on them. That's the problem. Okay. In Italy, on the masses, there was a discussion on the possibility, because it was not clearly given, for example, to the people of the same family to sit one near the other without respecting the minimum distance of 2 meters. From a logical point of view, it's clear that if I live with my wife in my house, it's unuseful when I go to the mass that I sit 2 meters from her. There is no logic in this. But it was, this provision was clear and was enacted only when there was an authentic interpretation on this issue. The problem is that protocols are enemies of the interpretation of the law. But from the other point of view, I think that they are, they are the only effective way to implement the enjoyment of a fundamental right, even in cases of this difficulty. Just 2 minutes in order to close. There was a very, very huge discussion about, in the first moments of the pandemic, on the ban to go to the church while other exercises were open. For example, as I told you, tobacconists, but even places in which you can play what we call lotto. Lotto is a gambling game, very popular in Italy, and these places were open. And some people thought that it was funny that these places were open while the churches were closed. And so at a certain moment, at the end of March, I think, the government decided that going to the church to pray alone could be justifiable, just like to go gambling lotto. Okay. The problem is that I perfectly understand that at a certain moment the government had to decide to save some economical activities that otherwise could have a very, very huge problem. While, as you perfectly know, religion is not an economical activity. The great problem of this pandemic is that it has to preserve a lot of issues and a lot of values, while it has to preserve the main pillar of the human life, that is the right to life and the right to health. What I will try to say is that not only rights that have an economical impact must be preserved, at least in their core content. Also ideal rights, rights that have an ideal content and not a directly economic impact, but can improve the spiritual and personal elevation of the person, must be, at least in their core content, preserved and granted. because otherwise the risk is that there is a very strong impact of the pandemic measures on the personalities of the mankind, on the identity of the mankind, on the psychological aspect of the mankind, and this could create a lot of problems in the future. So it's necessary, obviously, to preserve the right to health. It's absolutely necessary to preserve the right to life, but also the core content of fundamental rights, which has not economic but a spiritual impact, must be preserved. Otherwise, there could be very, very huge problems in the future. Thank you very much. I think it's okay for today.
So thank you very much, dear professor, for this beautiful lecture and for being just on time as well. From my point of view, actually, it's very interesting to see the common points our countries share in terms of fighting against the pandemic. In Turkey, we also had huge debates regarding the principle of legality as well. And I just want to say a few words regarding it, just to make a clear comparison between Italy and Turkey. Unlike Italian constitution, the Turkish constitution empowers the president of the republic to declare a state of emergency if a pandemic can lead to a breakdown in public order. The president, however, chose not to rely on this provision, but he instead relied on his ordinary powers in Turkey. And within this framework, the presidency and especially the interior ministry have issued various regulations and decrees, and these severely restrict fundamental rights in Turkey as well. The directives provided for the closure of establishments such as restaurants, cafes, nightclubs, mosques, public bathrooms, sports centers, and similar places. And these directives also banned persons over the age of 65 with chronic disease or under the age of 20 from leaving their homes, and as well as restricting interstate travels. And at least on 10 occasions, I remember, these directives imposed general curfews over weekends in big cities as well. And the interesting point is the Interior Ministry imposed almost all of these restrictions in ministerial circulars, not even in the form of decrees you mentioned in Italy. And these circulars addressed provincial governors and grounded the limitations in Article 11 of the Law on Provincial Administration and several articles of the Law on General Protection of Public Health in Turkey. And none of these articles actually provide justification for the restrictions, because neither of them authorizes the executive to impose general limitations on fundamental rights. So in Turkey, all the measures seem contrary to the Turkish constitution as well, which requires explicit statutory authorization for the restriction of fundamental rights and freedoms. To summarize, the constitutional lawyers in Turkey didn't find the chance to argue even the necessity of the limitations, because we couldn't even overcome the problem of legality in Turkey, by the way. So now it's time to receive questions. We have time until 11:30, so it's time for the attendees.
Good morning. Thank you, Professor, for this interesting lecture. I've got two questions, if I may. First of all, I think we can all agree that in the future, more pandemics will happen. And since this is a global pandemic, it's argued in many states that states are restricting fundamental human rights without the support of adequate domestic laws. So my question is, in your opinion, do you think that ultimately after this pandemic has been dissolved, that there will be enough state practice and opinio juris in order to establish that in specific pandemic situations that are of a very severe nature, that a new customary rule has emerged, that although there is not sufficient domestic law to support such restrictions, that it might be possible under a new crystallized customary rule? And secondly, you talked about the restriction on the right to of religion. And in my opinion, marriage is inherently tied to the exercise of religion. And in many countries, a marriage in a church or a mosque is legally valid. with the restriction being imposed to not go to church or a mosque, essentially one can argue that one is not possible to enter into a marriage, which is also a part of a religion. Would you argue that this could result also in a violation of Article 8 of the European Convention on the Exercise of Private and Family Life? Thank you.
Mr. President, do you prefer that I answer now, or we must pick up some questions, and as you prefer?
Actually, it's up to you, dear professor, if you want to wait for the other questions and to answer all of them, but it's up to you.
No, I think that there are very interesting questions, so I prefer to answer suddenly and then to have other questions maybe in the future. Thank you for these really interesting questions. Obviously, I hope that in the future we can create a sort of international standards ruling the exercise of human rights in time of pandemics. But I see two problems. The first one is, I would say, an empirical problem. Italy is a part of the European Union. And I must say that it was very difficult for the European Union to create a standard, a general standard of regulation of this pandemic, honestly. The place of the European Union was very weak at the moment, and I am not sure that it will increase in the future. And my doubt is, if the European Union is not able to give a proper and general guidelines from the pandemic, will be possible to create these guidelines at a superior level, even if at an inferior level, just like the level of the European Union, it was so difficult to create them. Let's think about what happens with the immigration law. No, the problem with immigration law now is obviously not the question, the issues of people, of refugees, or asylum seekers, but people moving from one part of Europe to another part of Europe for their holidays and coming back and increasing the problem of the pandemic. What we are experiencing in Italy now is that a lot of people went to Greece or to Croatia or to other countries, and probably this created a very problematic issues, not because of the legislation of that countries and so on, but for the difficulties to trace that people, to make proper interventions on them, just like to prove if they have the virus, if they are the high temperature, because the airport, for example, are not fully implemented for this kind of issue. So it was difficult to create this kind of issue at the level of the European Union. In my opinion, it will be more difficult to create it at a higher level, but I think it would be the only chance to fight really against the pandemic. As for the right to marriage, it's interesting because in Italy there was a very, very interesting situation on this. At a certain moment, at the end of March, the Ministry of Interior published a circular letter, according to which the marriage celebrated in the church could not be considered as banned. They were lawful, while there was the ban for all the religious acts of worship. The religious marriages ought to be considered lawful. And this created obviously a strong debate on, because if there is a ban for all the religious celebrations, this could include also the marriages, but the marriages were not considered as banned. But told the Ministry of Interior, they are lawful only if you have not more than 5 people inside the church. This fact, and the fact that it was impossible, obviously, to go to the restaurant after the celebration because of the fact that the restaurants were closed at that moment, created the fact that de facto, even if it was possible to celebrate a marriage, nobody celebrated his marriage or her marriage, because you know that in Italy there is a strong tradition according to which after the celebration there is a moment of feast and so on. I don't know if maybe someone celebrated his or her marriage, but it was not something that was so common, at least. So it was something that was permitted by the law, with the strange circular letter against the rule of law, but in the same time, even it was in abstracto permitted, from a concrete point of view, it was something that was substantially unapplicable. So it was not a violation of Article 8 because a celebration was possible, but de facto it was quite impossible to celebrate a marriage.
So thank you very much, Professor, and thank you very much for your feedbacks for the question. So we have 9 minutes to receive a few questions as well. You can raise your hand, the attendees, or you can write your question in a written form in the questions and answers part as well.
I see a written question from Mr. Begun or Ms. Begun Gukchek. How can be established a fair balance between measures, restriction come with COVID-19 and public health? What is the ultimate limit of restriction and fundamental human rights in a pandemic? Can I answer to this?
Yeah, sure, Professor. I think that was asked in a private message, so I couldn't see it.
Probably.
Yeah, please, yeah.
A fair balance between measures and public health. This is probably the main point of every kind of discussion. As I told you, the approach of the Italian Constitutional Court, and an approach that was not unofficial because it has been written in an official document of the court, but in the same time, it was not in a decision. It was not written in a decision. It is something that in an official document of the court presenting the work of the court in the year 2019. And in this situation, the president of the Constitutional Court expressed her view on this. The only possibility is to create a proper balance, giving to the fundamental rights different from the right to health and to life, the possibility to be exercised. What does it mean? This is obviously very, very complex, but what, in my opinion, is important is that the protection of the right to life and right to health cannot nullify the other rights. This has been expressed, however, in a decision of the Constitutional Court, even in a completely different case, the so-called Ilva case. Ilva is a very important factory of iron products in the south of Italy, and it created a lot of problems for the public health. There was a strong discussion also from the political point of view, but in the same time, it obviously permits to a lot of people to have a job in the south of Italy that is not a part in which it's so easy to find a job to the people of Taranto, this town. And in this decision in front of the Constitutional Court, the Constitutional Court explicitly told that the right to life, even if the pillar of the human rights, cannot be considered as so huge and absolute to nullify the other rights. Even in that case, in the case of Ilva, the right to economic initiative that is guaranteed by the Article 41 of the Constitution. So in that moment, when the Ilva case has been told, we have the formal insurance and the formal guarantee that in a constitutional framework, the protection of the right to health and to life cannot nullify the other fundamental rights.
Okay, dear Professor, thank you very much for the answer. We have 5 more minutes to receive questions, and I think no. So we are waiting for another questions.
I see 2 hands from Ertan Ildiz and Merve Serpa.
Yeah, and I also saw the hand of Ertan first. So first Ertan Ildiz, then Merve Chapar, please.
Okay. Hello, everyone. Can you hear me?
Yes, yeah. Sure.
Okay. Okay. I want to ask a question about this state of emergency, either related to COVID pandemic or other economic or terrorist attacks, something like that. You know, during the state of emergency, division of the power is blurred, and executive authorities can largely enlarge their domain at the expense of the enjoyment of the human rights. I mean, they can take decisions that can lead to severe human rights violation. So what kind of legal instrument can it be developed to stop executive branch from abusing state of emergency for their, political gains? Because we have witnessed such a kind of situation in Turkey in past 4 years, and presidential executive was not related to the state of emergency, and Constitutional Court refrained from revision on these decrees. So, what can we do to stop the executive branch abusing the state of emergency for their political gains? Thank you.
The answer that I have in my mind from this point of view is that I am not a politician, so I cannot find political solution for this kind of so-called abuse of law. And I obviously am not involved in the Turkish situation, and I don't know exactly what happens. What I know about Turkey is that constitutional court is working, and I think that constitutional courts all over in the world, in the world of the European Council, are working, and I think that we have to trust of our constitutional courts. I think that constitutional courts may be a pillar and must be a pillar for the developing of human rights and the effective guarantee of human rights. I had the honor and the chance to meet and to talk with Mr. Zulfü Arslan. I think the president of the Turkish Constitutional Law is a very, very, very strong and great jurist, and I think the court under his direction is working very well. So I think honestly that the only guarantee against the abuse of powers is the rule of the constitutional tribunals that are and must be a very, very strong guarantee for the complete guarantee for the human rights.
Thank you very much, Professor. As a last question, we will receive the question of Merve Çapar, please.
Okay, can you hear my voice?
Yeah, sure.
Okay. First of all, thank you, Professor, for your great lecture. It's a pleasure for us to learn from you. You highlighted right to education in your lecture, and I read some news yesterday on criticisms of UK education policy. According to the news, in UK, final exams were cancelled due to COVID-19 pandemic. State schools teachers argue that their students have been hit much harder than those at private institutions, as the algorithm graded students based on their school's past performance. Can we consider this as discrimination against students based on their economic status? Is it a breach of ICCPR's Article 2, Paragraph 1, as it states each state party to the present covenant undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. Does UK government's action has any legal basis to do this from your point of view? Thank you.
Thank you for your really, really crucial question. Honestly, I don't want to give opinions about what happens outside of Italy, obviously, but it's quite clear for me that a system in which the final mark of your education system with the impact that it has on your university and academic choices obviously is something that can create very, very, very strong problems, and it can create a proper discrimination of people. And I think that a lot of people, this in Italy happened a little bit less because it is a little bit less important, the final mark at the end of your scholastic career, in the sense that a lot of academia and universities in Italy, very prestigious, they manage by themselves. It seems a little bit curious, but they manage themselves in the fourth year and not in the fifth year, that the year of the final mark of the high schools, the admission to the university. For example, the Polytechnic University of Milan, it has its own tests on the fourth year of the high schools without any kind of agreement with the high schools for the admission to the Polytechnic University. So the final mark that you have, in the end, it is not so important. But when this mark is so important and it's calculated to the dictatorship of algorithms, dictatorship of algorithms is not my expression, obviously, but it is an expression of a very famous writer. When this dictatorship becomes so important that can create this kind of situation, obviously it recalls us to a very, very strong reflection on discrimination. And in my opinion, the only way to cheese this discrimination is to create a proper system of online, of distance education that can be respectful of the exigencies of all people, regardless their income, regardless their richness, and to assure a proper evaluation that can be affordable for everybody. I think that this must be an investment that must be made in the next 10 years, and is something on which I think the international groups must be very, very aware of the importance of this.
Okay, so we have exceeded our time for 2 minutes. I would like to thank Mr. Vincenzo for this beautiful presentation, and I also want to thank all the participants for this questions. I also thank Professor Sözer for giving this chance to me to moderate this session. So thank you very much to all the participants.